Okay. Good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you can remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Lastly, I need everyone to raise your right hand for me, please. Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes. Yes.
Thank you. Let's begin on the ladies' side with Miss Blackman. Miss Blackman, Blackman, sorry. You're charged with one count of simple assault. This is a misdemeanor offense. Bond is going to be set at $3,000. You're charged also with one count of battery, which is bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Sonia Hewitt. Do you understand that, ma'am?
Yes.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Um, are you currently working? Yes or no?
Yes.
And you put down $0. It's
Mhm.
$600 and then it's crossed out and then it says $0.
Um, question, what's that for again?
Let me ask it this way. How much do you make per hour?
12.75.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back. Miss McDaniels? Miss McDaniels, ma'am, you're charged with one count of misdemeanor possession of marijuana. Bond is going to be set at $1,500, and you're charged with one count of driving a vehicle with no tail lights. Bond is going to be set at $500. Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, Your Honor.
Okay, ma'am, you're free to go back. Miss, is it Medume?
Hello, Your Honor.
Good morning, ma'am. How do you pronounce your last name?
Madome.
Medume. Oh, I got it right. Ma'am, you're charged with one count of simple battery, family violence. This is a misdemeanor offense. Bond is going to be set at $4,000. There's going to be a stay away provision on this bond to stay away from a Brian Barnes. Do you understand that?
Yes, we live in the same home. Like we rent rooms in the house.
Okay. I will come back to that in a second, okay? Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Please.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, you said that, is it that the two of you rent a room
It's like a
in
boarding house.
boarding
Oh,
house?
that's it. That's it.
And
Okay,
it's-
sir, whoever just logged on iPhone, would you please turn your camera on? And iPhone 45, I need you to turn your camera on. I need you to identify yourselves. And I'll come back to you, ma'am. I'm sorry, I just got to take care of this. Okay, iPhone. Hello. Hadn't seen you in a long time.
How you doing, Judge?
I'm doing well. Who are you representing here today?
Vanessa Medley.
I'm actually speaking to her right now. So
Okay.
you have perfect timing. So ma'am, since you've hired an attorney, I'm going to start this over again, speaking to your attorney, okay? So I have set a bond at $4,000 for this offense. I've placed a stay away provision on the bond to stay away from a Brian Barnes, and that's where we were just having a discussion. So she said that they live in sort of a rooming house situation or rent a room. So this is what happens. Whenever you can't imagine how many of these cases we get a week of battery, simple battery, criminal trespass, people getting in arguments, they're misdemeanor offenses, they're gonna bond out. What we don't want to happen is whatever dispute that led to her coming before me today to flare back up again tonight. So we place a stay away provision on the bond temporarily. They can petition for the solicitor's office to take a look at it. And if it's something they look and say, hey, we think this should be modified, they bring it back to us and we sign it. I've never known a judge to not sign it. But because I don't know her and I don't know him, I don't want to be in a situation where somebody's lying dead on the floor tonight because whatever action took place led to someone's death. But also, I tell people we just simply don't have the resources for law enforcement to be going to everybody's house to referee fights between adults. We got people who are getting guns stuck in their face, their houses are getting broken into. We need law enforcement at those locations and not where a person can just walk away. So those are basic public policy principles behind that. Do you know if this is a situation where your client has another place to go?
Your Honor, it was my understanding that the incident location was in fact her place. However, I'm with her father now. So she can be with her father. If the court wants, I need you to mute your phone because you're feedbacking.
Okay, so that's the other iPhone.
Yes, we both just logged on. We're outside the courthouse, Judge, and we got the.
So I am placing the stay away provision as it relates to Mr. Barnes, not to any location. So I can't kick Mr. Barnes out of that location if he's staying there because he's the alleged victim. If Mr. Barnes chooses to leave on his own, she can go back to that location. But the stay away provision is only as it relates to Mr. Barnes.
Understood.
And no contact, don't contact Mr. Barnes, any of that kind of stuff. Of course, as the lawyer, you can contact Mr. Barnes and you can do whatever you need to do to present your client.
Understood, Judge. And if ultimately Mr. Barnes is still going to be at that location, she'll be able to stay with her father, and we can make arrangements that she'll comply with the stay away order in every way the court intends.
Okay, and if she needs to have items removed from the home, make arrangements as she's bonding out so that there's a law enforcement officer there, because we don't want her to get accused of doing anything and for him to get accused of doing anything. So we just do that just so that there's a neutral party and we don't have to deal with they stepped on my toe as they were coming out of the house, that kind of deal.
Understood.
So she has a preliminary hearing date that's going to be set for November 8th, but it's going to get waived upon her bonding out, and she'll receive a new court date in the mail.
Judge, the only thing I would ask, if the bond amount is pursuant to schedule, I understand. Otherwise, because I know the family, mom and dad had recently divorced, they're in a transition period of getting sort of everything back on their feet. If the court would consider a slightly lower bond, it would just assist in terms of dad getting Miss Vanessa out of custody and start getting this situation behind him.
Sure, give me 1 second. So it looks like Miss Medley is on bond out of Fulton County right now for aggravated assault.
Now that I was not aware of. So that being the case, I would just thank the court for a $4,000 bond and leave that alone.
Yeah, there's so I'm gonna leave it the way that it is. And I always take a look. I will try to be fair.
Understood.
Yes. So is there anything else?
No, Judge, it's just good to see you again. And thank you so much.
Okay, it was great to see you. Tell your family I said hello.
I sure will, Judge. Take care.
Okay.
May we be.
Yes, sir. Have a good day.
Thank you.
You're free to go back, man.
Thank you.
You're welcome. Next we have Miss Monolyn, Monlyn. Hi, ma'am. You're charged with 1 count of simple battery. I've set the bond at $4,000. There's going to be a stay away provision on this bond, a stay away from a Destiny Barrera, Barreira. Do you understand that, ma'am?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir, I do not. You said my bond was 4,000, right?
Yes, ma'am.
Okay, thank you. Is that all you have?
Yes, ma'am. You're free to go back. Miss Powell.
Hi, Your Honor.
Good morning, ma'am. You're also charged with, actually it's battery, but I've set the bond at the same amount as Miss Monolyn at $4,000. There's also going to be a stay away provision on this bond, stay away from a Destiny Barrero. Do you
Yes, sir.
understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. Courtroom 20, well, it'll be by Zoom, but it will get waived upon your bonding out and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, ma'am, you're free to go back. Miss Silva.
Morning, Judge Gardner.
Good morning, Miss Silva, ma'am. You're charged with 2 counts of interference with custody. These are misdemeanor offenses. I've set the bond at $1,500 for each count, so that's a total bond of $3,000. And I'll let you ask whatever question you want to ask in 1 second. Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Please, Judge Gardner.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Now, I cut you off. What was it that you wanted to bring to my attention?
I was going to ask the court if they would consider a lower bond. I am trying to get back on my feet. I'm currently going to be starting Capella for my EDD and curriculum and instruction. So I have an ongoing court case with DFACS that this is going to affect. And I'm not a flight risk because I very much think that my children are would be in better suited custody with myself, and I'm working towards the proper channels to do that correctly.
Okay, Ms. Silva, what I'll do is this. Given the nature of these allegations, I'm going to set a $500 bond for each count. That'll be a $1,000 total bond.
Thank you, sir.
Ma'am,
Yes, sir.
please comply with DFACS and
Yes, sir.
comply with this stuff. I mean, this is it can be a short-term thing if you just attack it head on, deal with it, and then move on with your life.
Yes,
Your
sir.
children are gonna need you.
Yes, sir.
Okay,
Thank
ma'am? Do you have any, you're welcome. Do you have any questions for me?
I hope you have a good day. Thank you, Judge Gardner.
Thank you, ma'am. Okay, we're gonna save Miss Yusufu for last. Miss Zephyr. Give me 1 second, ma'am. Miss Zephyr, you're charged with 1 count of criminal trespass. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Ronnie Bradford. He's also going to have a stay away provision on his bond to stay away from you. Do you understand that, ma'am?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail for me to see if you qualify for the appointment of a lawyer. I'm sorry, ma'am.
You were cutting off. I didn't.
Oh, I'm sorry. Would you like for me to see if you
Yes.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No questions.
Okay, ma'am. You're free to go back.
Thank you.
Now let's bring up Miss is it Yusufu? And we're gonna bring up,
Hello, Your Honor.
hi, we're gonna bring up, hold on 1 second. Okay, I'm sorry about that. On the male side, we need to bring up Mr. Anderson, Mr. Foster, and Mr. Nieves. And I just need, I'm gonna address each of you individually, but you're all in the same position. So I'm gonna make the speech 1 time rather than doing it 4 times. Okay. And ma'am, how do you pronounce your last name?
Yusufu?
Yusufu. Okay. So Miss Yusufu, Mr. Anderson, Mr. Foster, and Mr. Nieves, you are all in sort of the same position. The same rights and privileges as I explained earlier, they apply to the 4 of you. You're in sort of a different category in the sense that you're being labeled a fugitive from justice. And what that simply means is that there's a warrant for your arrest out of another state. Now, you have additional things to consider with respect to that. You have the right to challenge the warrant, or if you believe that you are the person named in the warrant and that the warrant does show a charge, you can waive that hearing and then require the other jurisdiction, which is, we call it the requesting jurisdiction, to come and pick you up and do what they call extradition, take you back to that other location. The first thing I want the 4 of you to understand is that it is in each of your interests to hire a lawyer to represent you in whatever jurisdiction. And when I go to each person individually, I'll explain the allegation that's being levied against you. But if you were to waive the hearing today, then the requesting jurisdiction has a minimum of 30 days, a maximum of 60 days to come and get you. If they do not come and get you within that time period, you will get released out the front door. But it doesn't mean that the warrant goes away. So if you're released out the front door, you can encounter another law enforcement officer 5 minutes after you're released, and they run your information and see that there's a valid warrant for your arrest, and the situation starts all over again. Generally, the time period goes a lot faster, but the statutory time period is 30 days, and then the requesting jurisdiction can ask for an additional 30 days. If you decide that you want to fight this, sometime between now and the next 90 days, there will be a hearing to determine whether you are the person named in the warrant and whether the warrant does in fact show that there is a valid existing charge. At the end of that hearing, if the judge makes that determination, then the judge will sign off on the extradition warrant, and then that 30 to 60 day period will begin to run at that point. Is everyone with me so far?
Yeah.
Does anyone have any questions so far?
No.
Okay.
I do,
Miss-
Judge.
Yes, ma'am.
I just wanted to know, you mentioned earlier that the time frame typically goes a bit faster than the 30 to 60 days.
It can, ma'am, but I can't promise you. All I can tell you is that they have 30 days at a minimum, and it could be up to 60 days. I've had situations where the detective is waiting at the jail for the hearing to be over, and they take the person. So the fugitive squad is in contact with these jurisdictions, so they'll know what time period, what's going on. They'll know all of that stuff. Nobody is speaking to me about that. Does that answer your question?
Yes, sir, it does.
Okay, so Miss Yusufu, you are here. It says that there is a warrant for your arrest out of Collin County Sheriff's Office for fraud. And I do have the warrant number if you want the warrant number.
May I grab a pen, please?
Yes, ma'am.
Thank you, just one second. Yes, I'm ready to take that now.
Okay, it is 416-82811-2020.
Thank you, Judge.
And they said that it will extradite you. And I'm trying to see. Do you have any idea of what you want to do, whether you want to have the hearing or waive the hearing?
I believe I want to waive the hearing.
Okay, so you should have some waiver forms there, and you can sign off on that, and they will send them to me, and I will sign off on it. And the time will begin to run today, but I would encourage you to try to, as quickly as possible, to get a lawyer, because especially during this pandemic, I've seen a lot of jurisdictions where they will just go ahead and they'll just go ahead and grant a bond. So I can't give you a bond, but if a bond is granted for this, they'll send us the information and we'll release you out of the front door. Okay.
Yes,
All
sir.
right. So that should conclude the ladies' side. And when Miss Yusufu signs off on it, she can go back. Now, are you Mr. Anderson? Mr. Anderson, come forward, please. Mr. Anderson, sir, do you have any questions so far?
No, sir.
Okay, so it says here that you are wanted out of looks like it says St. Clair County Sheriff's Office for recovery of stolen property. And it says that they placed a hold on you to be picked up. I have your warrant number also. Do you want that?
No,
I'm sorry, sir.
I do not want the warrant number.
Okay. Do you know whether you want to have the hearing or waive the hearing?
I want to waive it.
Okay. Once you sign off on that, sir, you'll be free to go back. And again, please, as if you can, get an attorney to represent you up there, and it may make things go a lot smoother. Mr. Foster. Mr. Foster, sir, do you have any questions?
No, sir.
Let me read to you what the allegation is. It says that there's a warrant for your arrest out of, oh my God, it's hard to read this handwriting. It looks like it's Morrilton Police Department.
Morrilton.
Morrilton. Okay. It's an allegation of possession of dangerous drugs. So you want your warrant number? Okay. Do you know what you want to do, sir?
I want to waive it.
Okay. Okay. Once you sign the waiver, sir, they'll send it over to me, and you'll be free to go back.
All right.
Okay. Mr. Nieves.
How you doing? Good morning, sir.
Good morning. Do you have any questions for me, Mr. Nieves?
No, I do, sir.
Okay. The allegation in your case is that there is that you're wanted out of Springfield, Massachusetts.
Correct.
Do you know whether you want to waive or have a hearing?
No, I want to waive it, sir.
Okay. And again, hire a lawyer up there as quickly as possible. And when you sign off the waiver, you'll be free to go back.
Perfect.
Okay. Thank you, sir.
You're welcome, sir. Have a good day.
You too. I can take a pause while they sign off on those if you
Okay.
need me to. Okay. Just let me know when we're ready to get back going.
Yes, sir.
Your Honor, they have signed and they have their copies, their one copy.
Okay. All right, well, let's get back up on the horse. Let's start with Mr. Marcus Alexander Henderson. Mr. Henderson, sir, you're charged with one count of violating Georgia's Controlled Substance Act. I have denied bond on that offense. You're charged with one count of distracted driving. I've set bond at $500. One count of violation of Georgia seatbelt law. I've set bond at $500, and one count of driving a vehicle with no insurance, and bond is going to be set at $1,000. Because of this felony offense, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. You're going to also have a bond hearing date set for November 11th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. You do qualify, Mr. Alexander Henderson. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yeah, why was the bond denied for the marijuana charge?
Let's see. I'm going back. I think it's because you were on bond. Hold on. Yeah, you're on bond out of South Fulton from a October 19th arrest for battery family violence. That's
Yes,
why I was denied.
All right.
Okay, sir, you're free to go back.
Thank you.
You're welcome. Mr. Anthony. Good morning, Mr. Anthony, sir. You're charged with one count of driving under the influence of alcohol. Bond is going to be set at $5,000. That's a misdemeanor offense. You're charged with one count of knowingly driving a vehicle with an invalid or canceled registration. Bond is going to be set at $1,000. You're charged with one count of driving a vehicle with your license not on your person. Bond is going to be set at $500. And one count of driving a vehicle with no tag. Bond is going to be set at $500. These are all misdemeanor offenses. So you're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you plan on hiring your own lawyer or representing yourself?
Hire your own lawyer.
Okay. Do you have any questions for me, sir?
What's my total for my bond?
Your total bond is going to be $7,000.
All right, thank you.
You're welcome. Mr. Bradford. Mr. Bradford, sir, you're charged with one count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Jessica Zephyr. Do you understand that?
Yes, sir.
And she also has a stay away provision to stay away from you.
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Bradford. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yes, sir. Could you lower my bond a little bit because I'm on a fixed income? I get SSI and it's not much. You do that for me, sir. I would really appreciate it.
So, Mr. Bradford, let me ask you this question. Well, no, I'm not going to ask you that question. The allegation involving you and Miss Zephyr is basically y'all could have been like 13 years old.
I know.
I don't so again, these bonds are not meant to be punitive, but at the same time, can you imagine the resources that you and Miss Zephyr have used up because y'all couldn't act like adults? Can you imagine the person in this county that needed a police officer there because somebody had a gun pointed in their face and they didn't have a law enforcement officer there because you and Miss Zephyr could not act like adults? So, sir, what am I to do? Give me a suggestion.
I accept, Your Honor. I accept.
I'm sorry.
I accept the,
Okay.
thank you.
Okay. All right, sir. You're free to go back.
Thank you.
Mr. Buckley.
Yes, sir.
Mr. Buckley, sir, you're charged with one count of robbery by sudden snatching. So, again, this is a situation of adults acting like children. But robbery by sudden snatching is a felony offense. I'm going to set your bond at $7,500.
Yes, sir.
There's going to be a stay away provision on the bond, a stay away from a Talaula Ma'alolo.
Ula Malolo.
What you said, sir, because I cannot pronounce that. You're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. You do understand the stay away provision, correct?
Yes, sir.
Would you like for me to see if you qualify for the appointment of a lawyer? Or
I have-
you're gonna hire your own?
I have one, sir.
Okay. Do you have any questions for me?
My bond was 7,000,
500.
7,500.
Yes, sir.
Yes, sir.
Okay, you're free to go back.
Yeah.
Mr. Davis. Mr. Davis, sir, you're charged with one count of simple battery. This is a misdemeanor offense. Bond is going to be set at $4,000. You're also charged with one count of criminal trespass, which is also a misdemeanor offense. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond, to stay away from a Fatima Murphy. Do you understand that, sir? Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? About how much do you make per hour?
$15.
Okay. You do qualify, sir. I'm going to, and I'm sorry, would you say that amount again? I'm sorry, I didn't hear anything.
$15 an hour.
Okay, thank you, sir. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Delgado. Mr. Delgado, sir, you're charged with one count of simple battery. This is a misdemeanor offense. Bond is going to be set at $4,000. You're also charged with one count of cruelty to children in the third degree. Bond is going to be set at $3,000, and one count of obstructing an officer. Bond is going to be set at $2,000. These are all misdemeanor offenses. Hold on one second. Okay, Mr. Delgado, I missed this the first time. The simple battery charge is going to be dismissed. They did not name a victim,
All right,
and that is a material element
okay.
for simple battery. Doesn't mean they can't bring this charge back. But I have to follow the law just like everybody else.
I'm good.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Delgado, and I'm going to appoint a lawyer to represent you. Now, I'll tell you, the solicitor's office, they generally will accuse these cases, meaning they will formally charge the case by the time this November 8th date comes around. And they actually sit at their desk and they type up what's called an accusation. So this charge will probably come back, but for now, it's not going to be there as you bond out. Do you have any questions for me?
We're gonna see what, so what's the total?
$5,000.
All right, that sounds good. Appreciate it.
Okay, sir, you're free to go back. Mr. Fuller. Good morning, Mr. Fuller. Sir, you're charged with driving under the influence of alcohol as a second offense. This is still a misdemeanor. The bond is going to be set at $7,500. You're charged with one count of improper lane change. Bond is going to set at $500. You're charged with one count of possession of a weapon during the commission of a crime. Bond is going to be set at $5,000. Charged with one count of violation of Georgia Controlled Substance Act. Bond is going to be set at $3,000. Charged with one count of possession of violation of Georgia Controlled Substance Act, possession of a Schedule I narcotic. Bond is going to be set at $3,000. And you're charged with one count of use or possession of a drug-related item. Bond is going to be set at $1,500. Because there are felony offenses that are contained in here, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. The date will get waived upon your bonding out, and you receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, Mr. Fuller. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
What's my total? Mine?
Mr. Fuller, you're making me do math on a Friday morning. Okay, hold on, sir.
Yes, sir.
By my public school math, it's $20,500. Okay, sir? All right, you're free to go back. Mr. Glover. Mr. Glover. Sir, you're charged with one count of obstructing or hindering law enforcement officer. That's a misdemeanor. Bond is going to be set at $2,000. You're charged with one count of pedestrian walking along the roadway. Bond is going to be set at $500. You're charged with one count of theft by receiving stolen property, being a firearm. That's a felony offense. Bond is going to be set at $5,000. Charged with one count of possession of a firearm by a person under the age of 18. But that's a misdemeanor. Bond is going to be set at $3,000. Finally, you're charged with one count of misdemeanor possession of marijuana. Bond's going to be set at $1,500. Because of the felony offense, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me, Mr. Glover?
What's my total for the bond?
$12,000.
Thank you.
You're welcome, sir. Mr. Hosher? Hosher? Sir, you're charged with 2 misdemeanor driving related offenses. The first is driving a vehicle on an expired tag, bond set at $500. And the second offense is driving a vehicle with a suspended or revoked license. Bond is set at $1,500. These bonds are set by schedule, which means they're automatically set. You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Appreciate it.
You're welcome. Mr. Lewis.
Good morning.
Good morning, Mr. Lewis, sir. You're charged with 1 count of battery. This is a misdemeanor offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from an Eric Mann. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
No, sir. Thank you.
Okay, you're free to go back. Mr. Lowry. Mr. Lowry, sir, you're charged with 1 count of misdemeanor possession of marijuana less than an ounce. The bond is set for this offense by schedule, which means it's already set or automatically set at $1,500. You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Lowry. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back. Mr. Maderos. Mr. Maderos, sir, you're charged with 1 count of felony possession of a controlled substance. Bond is going to be set at $3,000. This is a felony offense, so you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Mr. Maderos, at least from what I read, it looks like you may have been close to having maybe some bad things happen to you. If you're in a situation where you believe that you may want to go through drug court, that is something that can be available to you. You don't have a criminal history. Would you like for me to see if you qualify for the appointment of a lawyer? Okay, I'm going to find that you qualify for the appointment of a lawyer. I'm going to ask you to have a serious conversation with your lawyer about whether some kind of intervention is necessary for you. Okay, sir? All right, you're free to go back.
Thank you.
Mr. McQuarrie.
Good morning.
Good morning, Mr. McQuarrie, sir. You're charged with a number of serious offenses. You're charged with one count of aggravated assault. Bond is going to be denied at this point on that charge. Charged one count of criminal damage to property in the second degree as a misdemeanor. Bond is only set at $5,000. Charge of one count of reckless conduct as a misdemeanor. Bond is going to be set at $3,000. Charge of one count of violation of Georgia Controlled Substance Act. Bond is going to be denied at this point. You're charged with one count of use or possession of drug-related objects. Bond is going to be set at $1,500. That's a misdemeanor. You're charged with one count of simple battery. Bond is going to be set at $4,000. That's also a misdemeanor. You're charged with a felony count of false imprisonment. Bond is going to be denied. Another drug-related charge, violation of Georgia Controlled Substance Act. Bond is going to be denied on that felony. And finally, possession of a weapon during the commission of crime, which is a felony offense. Bond is going to be denied. There's going to be a stay away provision on this bond to stay away from a Taylor Collier. Do you understand that, sir? I'm sorry.
Yes, sir.
Your preliminary hearing date is going to be set for November 9th at 8:30 in the morning. You're going to also have a bond hearing date set for November 11th at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Sir.
You do qualify, Mr. McQuarrie. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. McKinney?
Yes, sir.
Mr. McKinney, sir, you're charged with one count of misdemeanor theft by taking. Bond is going to be set at $2,000, and one count of simple battery. Bond is going to be set at $4,000. These are both misdemeanor offenses, but there's going to be a stay away provision on this bond to stay away from a Demetria Lawrence. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. McKinney. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Thank you, sir.
You're welcome. Mr. McNeil?
How you doing?
I'm doing well. Mr. McNeil, sir, you're charged with 3 drug-related offenses, okay?
Yeah.
So for the first violation of Georgia Controlled Substance Act, charge, possession of marijuana over an ounce, bond is going to be set at $5,000. For possession with intent to distribute or sell, that's another felony offense. Bond is going to be set at $10,000. And then possession of MDMA as simple possession, bond is going to be set at $3,000. These are all felony offenses. So you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. McNeil. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
Yes, sir. So total bond is 18,000.
Yes, sir. All right, you're free to go back. Mr. Nguyen. Mr. Nguyen, good morning, sir. You're charged with one count of battery. Bond is going to have to be denied at this point pursuant to Georgia statute 17-10-1 because it looks like you're on probation. I got a copy. There's going to be a stay away provision on this bond to stay away from a Sanyata Young. Do you understand that, sir?
Yes, sir.
Your preliminary hearing date is going to be set for November 8th at 8:30 in the morning. There's don't normally have misdemeanor bond hearing dates, but that date can be held, or that hearing can be held on November 8th if necessary, but your lawyer has to file the appropriate paperwork to put the state on notice. Now, let me explain to you about this statute as to why your bond is being denied right now. Normally, on a misdemeanor offense, you have a right to a bond. However, if you're on probation and you're charged with a misdemeanor that involves violence, bond has to be denied at that initial hearing. Doesn't mean you can't get bond tomorrow. Doesn't mean you can't get bond on Monday. It just, I can't set it at the initial hearing. Okay.
I'm just trying to make it to my brother's wedding next week. So what are my next steps?
So speak to your lawyer about seeing if they'll do sometimes what they call a bond waiver, where you waive your hearing, they consent to a bond, you get out, your case goes over to state court, and everything moves along. But that is the position that you're in right now. But like I said before, it's not something that where you have to wait until November 8th. It's just they don't allow the first judge to set bond under those circumstances.
Okay.
Okay.
And, yes, and this person that I'm not allowed to see, they can also dismiss that, correct?
Well, what happens is they can request for that to happen, but the solicitor's office makes their own independent determination, because, you know, there have been people who on one day say, I want this person to be released, and then the next day that person kills them. So they look into it. They'll look into it. They will look into it. So it's not impossible, but I'm not going to make you believe that it's just as simple as this person saying, I don't want to prosecute. And then that's what happens. Okay.
Okay, that's all right. Thank you.
Okay. Now, did you want me to appoint a lawyer to represent you?
I believe I have a lawyer.
Huh?
I have a lawyer.
Okay. Make sure you speak to your lawyer as quickly as possible and see if your lawyer can get in contact with someone over in the solicitor's office, and so they can at least discuss your case. Okay.
Thank you, sir.
All right. You're free to go back. Mr. Please. Mr. Please, sir, you're charged with one count of obstructing an officer. That's a misdemeanor offense. Bond is going to be set at $2,000. You're charged with one count of loitering or prowling. It's also a misdemeanor offense. Bond is going to be set at $1,000. You're charged with one count of possession of a weapon during the commission of a felony. I'm setting the bond at $10,000. You're charged with one count of possession of marijuana more than an ounce. I'm setting the bond at $10,000. And you're charged with one count of possession with intent to distribute marijuana. I'm setting the bond at $10,000. These, because of these felony offenses, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you have your own lawyer?
I plan on getting one.
Okay. Do you have any questions for me, sir?
How much an hour?
$33,000.
All right, that's fine. Appreciate
Okay,
it.
sir. You're free to go back. Mr. Skillings.
How you doing, man?
I'm doing well. Mr. Skilling, sir, you're charged with one count of affray and one count of public drunkenness. There's going to be $1,000 bond set for each offense, and these are both misdemeanor offenses. You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you have a brother named Elijah?
Yeah, that's my brother. Yeah.
Okay. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir, I do.
I'm sorry?
No, sir.
Okay, you're free to go back, Mr. Skillings.
All right.
Mr. Talbert, good. We're in the afternoon hour now. Mr. Talbert, sir, you're charged with one count of criminal trespass. This bond has been preset, and I'm gonna leave it the way that it is. It has the fee amount attached to it, so it's gonna sound strange. Okay, it's $530. Possession of marijuana less than an ounce. It says $1,135. I'm just going to leave it the way that it is. You're charged with 2 felony offenses, both involving possession of a Schedule 1 narcotic, and I'm setting the bond at $5,000 apiece for each of those offenses. Because of the felony offense, you're going to have a preliminary hearing date set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Talbert. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. It did my first offense, my first time getting in trouble. I was trying to see, could I get a signature bond?
No, sir.
Can you tell me my amount of bond there?
It looks like it's gonna be $16,600, or I'm sorry, $16,060.
$60.
Hold on, I'm sorry. My math is all off. $16,665.
$16,665.
Yes, sir. Okay, you're free to go back, Mr. Talbert. Mr. Thomas.
Good morning, y'all.
Good morning, Mr. Thomas. This is your lucky day. You've been charged with one count of driving under the influence, but that charge is going to be dismissed because the officer did not place anything in the narrative about any reason that you could be suspected of driving under the influence.
Thank God.
The improper lane change, the officer did make out a probable cause for that. So the driving under the influence charge, that WA is going to be dismissed. The improper lane change, that's a misdemeanor. You're going to have a bond set at $500. You're going to have a preliminary hearing date set for November 8th at 8:30 in the morning. That date will get waived upon your bonding out, and you receive a new court date in the mail. Now, it's important for you to understand, Mr. Thomas, that even though it's getting dismissed today at this hearing, doesn't mean this charge can't be brought back by the solicitor's office. And it most likely will get with the officer and make out probable cause. You did not fill the form out. Does that mean you intend to hire your own lawyer?
I Yes, I probably will in the near future, if need be, so.
Okay. All right. Do you have any questions for me?
Yes, I do, if I may ask you, if allowed.
I can't discuss the facts of your case.
Oh, okay, no.
Oh, so you said no?
No.
Okay, you're free to go back, sir.
All right, thank you.
You're welcome. Mr. Webb. Mr. Webb, sir, you're in the same position as the other person. You're charged with robbery by sudden snatching, which is a felony offense. And it's not a robbery in the classic situation. It appears to be an argument, and people decided to act less than like an adult. So I'm going to set a bond at $7,500 for the felony of robbery by sudden snatching. I'm going to set a bond of $5,000 for the simple possession of the VGCSA. There's going to be a stay away provision on this bond to stay away from a Johnny Wiggins. Do you understand that, sir?
Yeah.
Your preliminary hearing date is going to be set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Webb. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir?
It's worth for X. I'm really don't have no money, so is there any possible way that you could just lessen the fee just a little bit if you can?
I'm not, and I'll tell you why. Again, this goes back to what I've said. You're an adult. Miss Wiggins is an adult. We have people that have guns being pointed in their face, their back doors getting kicked in. We don't need law enforcement to be out refereeing arguments and disputes between adults. I mean, it says the allegation is that you took her phone and put it in your pocket and wouldn't give it back. Why do the police have to come out for that?
That was the case and wasn't the case, sir. I know you're not going through the details of it, but
I understand, but I'm just explaining to you that everybody has disputes in their relationships and their lives.
right.
How they deal with it determines a lot. We just don't have the resources to keep coming out dealing with adults that don't know how to act like adults. So, sir, I need you. Hold on, I'm gonna let you speak. I promise. I need you to understand that the next time you're in a situation where there's a dispute, try to exit out of it. Okay, so I interrupted you, Mr. Webb. Go ahead.
Yes, sir. I know it's part of the facts a little, but I had to. It's part of actually. It's all right actually.
Okay. All right, sir. You're free to go back.
All right. And you said my bond was what was my bond again, sir?
7,500 for the robbery by sudden snatching, and 5,000 for the violation of Georgia Controlled Substance Act.
Was that 13?
Yes, sir. No, it's 12.
Well, and I'm entitled to a lower percentage pay rate on it, or I gotta pay the whole
No,
fee?
you can go through a bonding company and pay a percentage of the bond amount. And again, I think there's 5 or 6 bonding companies that are authorized to write bonds in this county. You should contact each one of them, because some will work with you. They'll put you on a payment plan. It's a competitive business. So what you have to do that legwork.
All right.
Okay,
Thank
sir. You're welcome. Mr. Wells. Mr. Wells, sir, you're charged with 2 felony drug-related offenses. One is possession of marijuana over an ounce. I'm denying bond at this point on that charge. And you're charged with 1 count of possession with intent to distribute marijuana. I'm denying bond on that count. You're charged with 1 count of driving on a suspended license. I am setting a bond at $1,500, and you're charged with 1 count of following too closely. And I'm setting the bond at $500. Your preliminary hearing date is going to be set for November 9th at 8:30 in the morning. That date will get, also setting a preliminary hearing date for you. Strike that. I'm setting a bond hearing date for you for November 11th at 8:30 in the morning. Preliminary hearing date is set for November 9th. Would you like for me to see if you qualify for the appointment of a lawyer?
I want to say, is there anything I can do? Cause I started work November 7th, and I'll be able to pay everything. I was gonna see why my bond got denied.
It says that you're on bond from an arrest March 1st of this year in Clayton County for possession. Hold on. Says purchase, possession, manufacture, distribution, or sale of marijuana, and driving on a suspended license, and possession or use of drug-related objects. So 7 months later, you're arrested again on similar charges. You don't have to raise your hands, sir. Sir, I'm going to let you speak, okay? You asked me a question. I just answered it. Now, what is it that you wanted to tell me, Mr. Wells?
I was gonna say that the last charge that's on my record, it was not mine in my possession. It was on somebody else. I just got charged with it. It wasn't mine. They took their charge. They charged. It was in their possession.
Okay. I'm explaining to you why I denied bond. Now, if there's something that goes behind that, I've appointed a lawyer to represent you. That could be brought to my attention, and you can get a bond. So I am charged when I'm deciding whether to release a person on bond. I have to decide whether that person is a danger to the public safety, or whether that person may commit another offense while on bond. If I see that you were arrested in March on drug-related charges and driving on a suspended license, and now you're arrested here in October on drug-related charges and driving on a suspended license, I gotta look behind that.
Can I say one more thing?
Yes, sir.
I thought my license was getting back valid. I thought it was almost a year from my first DUI.
Sir, I again, that's why we appoint lawyers. If your license is still showing as suspended, you have to take steps to reinstate your license. It's not just, it doesn't automatically just become valid again. Okay. Anything else, sir?
Thanks.
All right. Mr. White.
Good afternoon.
Good afternoon, Mr. White, sir. You're charged with a number of offenses. You're charged with simple possession of cocaine. That's a felony offense. Bond is going to be set at $3,000. You're charged with possession of marijuana with the intent to distribute. Bond is going to be set at $10,000. You're charged with possession of marijuana less than an ounce. Bond is going to be set at $1,500. You're charged with having a dangerous drug outside of the container, and which is, just so you know, if you have anything that has a prescription on it, you're supposed to keep it in the prescription bottle. And if it's found outside of the prescription bottle, that forms the basis of this charge. That's a misdemeanor. Bond's gonna be set at $3,000. Charge one count of simple battery. That's a misdemeanor. Bond is going to be set at $4,000. And you charge a one count of criminal trespass. Bond is going to be set at $3,000. There's going to be a stay away provision on this bond to stay away from a Jada Jackson. Do you understand that, sir?
Yeah.
Your preliminary hearing date is going to be set for November 9th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Total,
I'm sorry, sir.
the total.
$24,500.
Damn. Okay, so you and I have a question. Okay, I'm not from here, right?
Okay.
I'm from New York.
Okay.
And I have court on the 9th in New York.
Okay.
Damn.
So, Mr. White, do you have anyone that can, do you have a lawyer up in New York?
I have a lawyer in New York.
Do you have anybody that can let your lawyer know that you're in custody?
I have to call around, but they only let me get 3 numbers out my phone, so I have to see.
Okay. So, if you're not able to get in contact with your lawyer, your case may go into bench warrant status if they don't know about this arrest. However, the fact that you are in custody here would form the basis for your not appearing in court up in New York. However, if there was any reason that you're placed on bond up in New York and you're told not to violate any other laws, this may form the basis of your having your bond revoked up in New York.
Oh, no, I don't have no bond in New York. They let me out RR.
Okay. All right, sir.
So you said 27,000? I'm at 20. What's the total?
$24,500.
Thank you, Your Honor.
You're welcome. Okay.
I'm gonna be everybody.